Thank you so much for joining us on a Friday. Even during a pandemic, we recognize that a Friday is still a sacred day. Before I begin discussing the program itself, I want to take a quick moment to thank the people who have made the symposium possible, some people that you'll be hearing speaking later today. First, this program was made in collaboration with the Rutgers Center on Criminal Justice, Youth Rights, and Race, and the Rutgers Criminal and Youth Justice Clinic, headed by Professor Laura Cohen, one of our moderators for today. Professor Cohen has been a guiding light in making the symposium, so thank you. And I also want to thank members of the symposium team, Madeline, Gail, our editor-in-chief, who is also going to be a moderator today, Jennifer Monhay, Mary Claire Patterson, and members of our symposium committee, Leah Dice, Gifty Minnow, Holly Maynard, Michael Lynch, and Matthew Grillo. So this year has been difficult for all of us because of the pandemic, but also because of the brutal and grotesque murders of George Floyd, Ahmaud Arbery, Breonna Taylor, and many, many more. Unfortunately, these injustices are nothing new to the nation, but fortunately, out of them have come a lot of productive discussions about how to combat these injustices. Most of these conversations have been focusing on policing, but as we all well know, they are not the only gatekeepers to justice. Prosecutors have the opportunity to become agents of change as well. So we're hoping that through this symposium, we can enter into the discussion and find out how we can build an anti-racist prosecutorial system. So in a moment, I'll hand over the program to Laura Cohen and Madeline Gail to be our moderators for today. But I do want to urge you guys that we want this to be a conversation. Please utilize the Q&A function on your Zoom in order to submit your questions so that we can discuss them during the discussion portion at the end of the event. And Maddie and Laura, you guys can take it away.
Thank you so much, Gisele. And thank you to everyone who's made this possible today. I'll go through those in a minute. I'm Laura Cohen. As Gisele mentioned, I'm on the clinical faculty here at Rutgers and also direct the Center on Criminal Justice, Youth Rights, and Race, which is an academic center here at the law school that is focused on addressing and undoing structural racism in the criminal and juvenile legal systems. It's my great pleasure to welcome you here today. This symposium has been a labor of love for me and the 4 talented and righteous student editors of the Rutgers Law Review over the last 5 months. Madeline, Gail, Gisele, Jennifer Monhay, and Mary Claire Patterson have devoted themselves utterly to making this possible, and it is through their commitment to achieving racial and social justice and their determination to use the power of the pen and the power of scholarship to bring that about has been really inspiring to me. So as Gisele mentioned, we are also very fortunate to be able to provide CLE credit for this program today. And I'd like to thank Joe Nagel and also the incomparable Habiba Johnson, who worked so hard to make the program possible. This program, the idea for this program, arose directly out of response to the unspeakable murders of George Floyd and Breonna Taylor and Ahmaud Arbery and so many others over so many decades in this country. As many of you who are affiliated with the law school know, our faculty came together over the summer and adopted a faculty resolution that committed all of the powers and all of the energy of the law school to undoing systemic racism. And this program was and is a part of that effort. And it is one of 4 symposia that we will host over the course of the next couple of months with amazing speakers, including today's, that will start to explore the role that prosecutors have played in the inequities, the gross disparities and inequities that define our criminal and juvenile legal systems, and the role that they can play in undoing those inequities. Those inequities exist at every decision-making point along the continuum of system involvement, and they are driven by every decision maker. Most of the public attention and blame focuses on the most visible actors, the police. But most of what drives the mass incarceration of Black and brown people in this country happens in the courts. And much of what happens in courts is controlled by prosecutors. Prosecutors operate largely behind closed doors, but they have sometimes exclusive and always outsized influence on every decision that is made. The decision whether to charge or not, the decision what to charge, the decision of whether to seek indictment or not, the decision to offer a plea bargain or not, and also extraordinary influence over sentencing decisions. And so without exploring the exercise of that power, without exploring the forces behind the exercise of that power, we cannot hope to undo the profound inequality and the profound injustice that define this system. And so that's our charge over the next 2 months. That's our charge for today. And we are so fortunate to have our 3 speakers who are here today with us and those who will join us later in the spring. So at this point, I would like to turn things over to Madeline Gail. Madeline is a 3L here at Rutgers. She is the editor-in-chief of the Law Review. She is also, I am proud to say, a clinical law student in the Criminal and Youth Justice Clinic. It has been an absolute joy and privilege to work with her over the course of this year. During her 2nd and 3rd year at Rutgers, she was the evening class representative for the Student Bar Association. And she is on her way to clerk for the appellate division here in New Jersey when she graduates in May. And it is going to be just an awful thing for all of us to have to say goodbye to her. So without further ado, Madeline.
Well, thank you for such a nice introduction. Hi, everyone. As Professor Cohen said, my name is Madeline. And it is my pleasure to introduce our keynote speaker, Ms. Davis, or Professor Davis. Ms. Angela Davis is currently a distinguished professor at law at American University. She received her JD from Harvard Law School and a BA in political science from Howard University. She also served as a law clerk for the former Chief Justice of the DC County of Appeals, Court of Appeals, Theodore Newman, and she's also was the director of the DC Public Defender Service. Ms. Davis is an expert in criminal law procedure and with specific focus on prosecutorial power and racism in the criminal justice system. She is the author of Arbitrary Justice, The Power of the American Prosecutor, and other scholarly work which won awards: Arbitrary Justice, The Power of the American Prosecutor, and Prosecution and Race, The Power and Privilege of Discretion. Ms. Davis, in a word, is simply amazing. Beyond her accomplishments, she has fiercely worked to provoke our thoughts, which we hope someday soon will lead to meaningful change to the prosecutorial system. So it is my pleasure to introduce and welcome Ms. Angela Davis.
Thank you so much, Madeline. And I want to thank the Rutgers University Law Review and the Rutgers Center on Criminal Justice, Youth Rights, and Race for inviting me to participate in this very important symposium on prosecutors, power, and racial justice, building an anti-racist prosecutorial system. I want to give a special thanks to Professor Cohen, to Gisele, and all of the students who worked so hard to put this symposium together. It's such an important topic, and I appreciate your interest, and particularly thankful to all of you who are here on this Friday afternoon to talk about these issues with us. The topic of my talk is prosecutors and race, responsibility and accountability. Prosecutors and race, responsibility and accountability. And by the end of the talk, I hope you'll know why I named it as such. I believe that prosecutors should be held responsible and should be held accountable for the situation we find ourselves in the criminal legal system today. And that is a crisis. I truly believe we are at a point of crisis in our criminal legal system, with 2.2 million people in prisons and jails, with 7 million or so people on probation and parole, with extraordinary unwarranted racial disparities at every step of the process. Black and brown people are more likely than white people to be arrested. Once arrested, they're more likely to be convicted. Once convicted, they're more likely to face stiff and long sentences. And I'm talking about similarly situated whites. African-American men are 6 times more likely to be incarcerated than white men, 2.5 times more likely than Latino men. And if current trends continue, 1 of every 3 Black American men born today can expect to go to prison in his lifetime, as can 1 in 6 Latino men compared to 1 in 17 white men. And the racial and ethnic disparities among women, although less substantial, are also very prevalent. So we're in a state of crisis, not only with regard to mass incarceration, but the unwarranted racial disparities. Black and brown people are treated worse than their similarly situated white counterparts at every step of the process. And that's whether we're talking about people charged with crimes or people who are victims of crimes. And we're talking about the arrest stage. Because of racial profiling, we find that Black and brown people are treated worse. The prosecutorial stage, which I'm going to spend a good bit of my time talking about today, on to sentencing laws that have a disparate effect at every single step of the process. And when I say similarly situated, I mean whites who are engaged in the same behavior as African Americans or Latinos are treated better than their Black and brown counterparts. And people who have the same criminal record or lack thereof, who are alleged to have engaged in the same behavior. And on the victim side, victims who have had the same experiences, Black and brown people are simply treated worse. Why is that? Well, the reasons are complex, right? There's no one bullet answer for it, right? There are socioeconomic reasons, the socioeconomic reasons that cause people to find themselves in the criminal legal system, right? We all know the connection between poverty and crime, trauma and crime, lack of public health and education and crime. But there are also discretionary decisions that are made in the criminal legal system that also produce these disparities, right? Discretionary decisions by officials in the legal system. Everybody's familiar with racial profiling, right? When cops stop Black and brown people and frisk Black and brown people and pass by whites who are doing the same things or doing nothing, as is often the case, they create a racial disparity, right? And when prosecutors decide to charge Black and brown people and don't charge whites who are engaged in the same behavior and have the same criminal record or lack of criminal record, they are creating a racial disparity, an unwarranted racial disparity, an unfair racial disparity in the system. So I hold prosecutors more responsible than other officials. And the reason why is because they're the most powerful officials in our criminal legal system. They, in essence, control the system through their charging and plea bargaining decisions, as Professor Cohen pointed out earlier, right? It is the prosecutor who decides whether an individual is going to be charged and what they're going to be charged with. It is the prosecutor who decides whether a person gets a plea bargain and what that plea bargain is going to be. Prosecutors alone make that decision. And it's very easy for prosecutors to bring charges against people. You might not think that based on how they've been treating these police officers and not charging them, right? When we've seen overwhelming proof of police officers killing, murdering Black and brown men, women, and boys. You know, we see it on videotape, yet charges aren't brought. You might think, well, maybe it must be difficult to bring charges. Actually, it's very easy. And why is that? Because the standard is really low. It's a standard called probable cause, more probable than not, right? If they have that scant amount of evidence, and it's a much lower standard than the proof beyond a reasonable doubt that they need to convict the person at trial. And because of that, many prosecutors engage in overcharging. By overcharging, I mean piling on charges simply because they have probable cause, even when they know they can't prove the charges at the time of trial. They know they can't prove it beyond a reasonable doubt. They pile those charges on. Why do they do that? Because it gives them an advantage at the plea bargaining stage, right? If I'm a person and I'm faced with, 10 counts of distribution of cocaine, and each count carries a 5-year mandatory minimum sentence, and I'm facing 50 years in prison, and the prosecutor offers me a deal to plead to one count, even if I'm innocent, and one count, I end up in jail for 5 years, which is a long time, I might take the deal even if I'm innocent. Why? Because going to trial is risky business. You don't know what a jury might do. And if I go to trial and I'm facing 50 years and I get convicted on every charge, I'll go to prison for the rest of my life. So I might take a deal, right? Even if I'm innocent, or even if I have a strong defense. This happens in courtrooms across the country every single day. This is what is passing as justice in courtrooms across the country every single day. And prosecutors control those decisions. Whether you get charged, whether you get a deal, it's totally up to them. And they make those decisions behind closed doors, and they are accountable to no one other than their supervisor, the chief prosecutor in that office, which I am going to talk about a bit later in my talk. And when you consider the fact that 95 to 97% of all criminal cases are resolved with a guilty plea, you can see why I say prosecutors are controlling this criminal legal system, right? People think all these, you watch these TV shows, Law and Order, 1, 2, 3, 4, and 5. I don't know how many Law and Order shows there are. I don't watch it. I can't watch that show. It drives me crazy. But if you watch these TV shows, you'll think there are all these trials going on. There are not a lot of trials going on. There are a lot of guilty pleas going on in courtrooms across the country, and prosecutors are controlling that process. So you see why I say they're the most powerful. Well, why do I say they also create and perpetuate racial disparities? I think they do. I don't think they do so intentionally. I don't think there are prosecutors sitting at their desk saying, oh, here's a Black person, arrested for distribution of cocaine. Here's a white person. I'm going to let the white person go and I'm going to charge the Black person. I don't think that's going on. I do not think that's happening. Maybe it is. I hope not. Could be. But I don't think that's what's going on. I think it's a lot more complicated than that. I think one of the reasons is implicit bias, which some of you may have heard of, right? We all suffer from implicit bias, right? That's the unconscious racism, unconscious views that we have about other people based on their race, their ethnicity, their gender, their sexual orientation, their skin color, their body size. It could be anything, but it's an unconscious thing. We're not even aware we're having that judgment about that person. It's unconscious, implicit bias, right? It's that thing that causes, a white woman on an elevator, a Black man gets on the elevator and she pulls a person a little closer and she moves over. She's not even aware she's doing it, but it's because she sees that Black man and it brings on that fear of this person. That's implicit bias, right? And we all suffer from some form of it as human beings, no matter your race, ethnicity, me, I do, you do, we all, we're not even aware of it. But when you are in a position of power, like a prosecutor, and that implicit bias that you hold is causing you to make decisions that impact a person's liberty or life, sometimes if we're talking about the death penalty, it is a huge problem that must be dealt with. And I do think that happens, right? The prosecutor who looks across the courtroom and, sees Jamal sitting at the table and, can't kind of really relate to him. Well, let me just give a more explicit example. Let's say a prosecutor does have a case in which Jamal, African-American man, let's say, young man, he has been arrested for distribution of cocaine, and his overworked public defender comes to the prosecutor and says, you know, Jamal doesn't have any prior convictions, and he actually has a drug problem. And he was really just selling to feed his habit. And, you know, he really, you know, he dropped out of school. He doesn't have many opportunities, but he really needs a drug program. And the prosecutor, you know, looks at Jamal and he's like, you know, where's the drug? Where's the drug? I don't have a drug program to offer him. And so sorry, but I'm going ahead with the charges, right? Another case might come before that same prosecutor. Todd, white kid, he's arrested for distribution of cocaine. You know, this is a hypothetical because Todd never would have been arrested, but bear with me. He's arrested for distribution of cocaine, let's say in his high school. He comes in with his lawyer who his family hired, who actually may have used to possibly worked in the prosecutor's offices and is now, you know, in private practice. He might even know some people in the office. And he comes in, he says, look, you know, please drop the charges against Todd. He has a drug problem and he was just selling to feed his habit. And his parents have found a residential drug program for him. He's ready to sign on and he's been accepted to college. This will ruin his life. He doesn't have a conviction. Prosecutor looks at him and remembers he used to do a few drugs himself when he was in high school. And he's like, wow, somebody gave me a chance. He can kind of relate to Todd. He don't want to ruin Todd's life. Todd has a future. He don't want to be responsible for that. So he gives Todd a break and he says, okay, finish the drug program. I'll dismiss the cases. We can expunge your record. Is that wrong? I don't think it's wrong for him to give Todd a break, you know, but Jamal deserved a break too. And would I call this prosecutor racist? No, I wouldn't, but his or her unconscious views caused him to make a decision which created an unfair and unwarranted racial disparity, right? But it's not just implicit bias. It gets even more complicated than that because there are some legitimate factors, race-neutral factors that prosecutors take into account when they're making their charging and plea bargaining decisions that have a racial impact, that cause racial disparities. So what do I mean by that? Well, the American Bar Association has what's called standards for the prosecution function. They also have standards for the defense function, standards for the judicial function. What these are, they're like guidelines that the American Bar Association believes that prosecutors should follow as they're making these all important decisions about charging and whether to dismiss a case and so on. And they list a bunch of factors that prosecutors should take into account. Things like, for example, the strength of the case. Well, we want the prosecutor to take that into account. If it's a weak case, we don't want them bringing charges when it's a weak case. If that, you know, putting people through that, putting the defendant through all of that, putting the victim through that, you know, wasting resources. If the case is weak and you can't prove it beyond a reasonable doubt, then you shouldn't be bringing it, right? You should dismiss it. That's legitimate, right? But how does a prosecutor determine the strength of the case? One of the things prosecutors take into account in determining the strength of the case is, do I have good witnesses? Do I have a good witness who can convince the jury, right? So if I have a case with a victim who is articulate, well-spoken, tells a good story, and is going to be convincing on the witness stand, then I might have a strong case and I may go forward, right? So let's say I've got a case where, you know, there's a lawyer who was robbed of her briefcase. And, you know, I sent out a notice for the witness to show up. She shows up on time for the witness conference. We have a good talk and we go over her testimony. She's articulate, she's dressed well. She speaks the king's English or queen's English or whatever. I'm like, wow, this is gonna be a good witness. The jury's gonna believe her. I'm gonna get a conviction, strong case, right? So that victim, her case is going to be given a lot of attention, and the defendant in that case is going to, you know, face a lot of time because I'm not giving a plea bargain here because I think I'm going to win at trial with this one, right? Maybe there's another victim, a woman, and let's say that for purposes of this discussion, racial disparity, let's assume this lawyer is white, okay? Another case, Black victim, a woman who, let's say her apartment was burglarized and they stole, I don't know, her some cash from her home and maybe, some equipment, some stereo equipment or something like that, a TV. And, they arrest someone for that offense. And the prosecutor sends a notice out to Ms. Jones. Ms. Jones show up for the witness conference. Ms. Jones shows up. She's not well-dressed. She's not very articulate. She doesn't really tell the story quite as well. And you're thinking, she doesn't really make a good witness. I don't know if the jury's gonna really believe her. I'm just gonna dismiss her case. So her case doesn't get the attention and the defendant in that case gets a break. Or another likely scenario, Ms. Jones doesn't show up at all for the witness conference because Ms. Jones has the type of job where if she misses work for one day, she loses her job. Or maybe she doesn't show up because she realizes, hey, this is the same prosecutor's office that prosecuted my son. I don't really want to be bothered. I'm kind of scared of those people. I'm not going to go down there. So she doesn't show up. And the prosecutor's like, well, she didn't show up. I guess she doesn't care anything about the case. So I'm just going to dismiss it. And that's another factor that the ABA says that prosecutors should take into account, the interest of the victim in prosecution. So if the victim is interested in prosecution, you don't have to do what the victim says, you don't represent the victim, but that's something you should take into account. If the victim's not interested, then you take that into account, maybe you don't. Again, these are legitimate factors, but you can see how they can and do have a racial impact. Not because the prosecutor's being racist or trying to, treat Black victims worse than white, or, trying to lock up more Black. That's not even in their conscience, but they're causing those disparities. So guess what? I don't give them a break just because it's not their fault. I really don't, because they are causing the harm. And if they are aware that they are causing this harm, this awful scourge on our criminal legal system, they have a responsibility to fix it. They have all that power and discretion. They can fix it with that power and discretion, right? I'm not particularly religious, but there's a Bible verse that says, to whom much is given, much is required. And that's the prosecutor. They're given all this power and they are required to use it to do justice. And that's the other thing. The United States Supreme Court says that, and there's a case called Berger versus United States, in which the Supreme Court, and I'm paraphrasing, but basically what the court says is it's not the duty of the prosecutor to seek convictions. It is the duty of the prosecutor to do justice. And what does doing justice mean? Doing justice sometimes may mean seeking a conviction, but doing justice also sometimes means dismissing a case or not bringing the case at all, right? The prosecutor represents not the victim, but the community, the whole community, right? And guess who is included in that? The victim is part of the community, right? All the rest of us in that prosecutor's jurisdiction, they're part of the community, but also the defendant. The defendant is part of the community too. And so the prosecutor must do justice for all. It's a hard job, but that's what the duty of the prosecutor is. And so I believe that prosecutors have the responsibility to end mass incarceration and to end these awful racial disparities. It's a big task, but they have the responsibility, in my view, to do everything in their power to fix all of this harm that they have partially caused. I'm not saying prosecutors are the only people who cause harm, they're not, but they are a significant part of it. I also believe, and I wrote an article about this some years ago, that prosecutors have an ethical duty to end mass incarceration, right? So there are these ethical rules that apply to all lawyers, the model rules of professional responsibility, and Rule 3.8 is the one that applies specifically to prosecutors. And in Rule 3.8, in the comments to Rule 3.8, it imparts the same sentiment as the Supreme Court in Berger versus United States. That comment says, the United States attorney, meaning prosecutor, talking about U.S. attorney, is the representative, not of, oh no, I'm reading the wrong thing. That's the language from Berger. The comment says, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. And then those standards, those same standards that I talked about earlier, the standards for the prosecution function, standard 3-1.2b, says that the primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict. It's just really reflecting the language of the United States Supreme Court. And it goes on to say the prosecutor serves the public interest and should act with integrity and balanced judgment to increase public safety, both by pursuing appropriate criminal charges and by exercising discretion to not pursue criminal charges in appropriate cases. And so there's more language, and in the interest of time, I won't go through it all, but they have an ethical responsibility, right, to fix the criminal justice system. I'll just read one more passage from another standard, 3-1.2. The prosecutor should seek to reform and improve the administration of criminal justice, and when inadequacies or injustices in the substantive or procedural law come to the prosecutor's attention, the prosecutor should stimulate and support efforts for remedial action. And I can think of no greater inadequacy or injustice than mass incarceration and unwarranted racial disparities. How am I doing with time? Do I have just a few more minutes?
You got 5 more minutes.
5 more minutes. Thank you, Giselle. So let me just close by saying, accountability, right? I've talked a lot about their responsibility. Let me talk a little bit about their accountability. What can prosecutors do? We need to hold them accountable. And how do we hold them accountable? Let me give you a couple of ways. One is they should be referred to bar counsel when they engage in prosecutorial misconduct. And I know Professor Yarashevsky is going to talk about that. And so I'm going to leave that to her, but they should be referred to bar counsel, and they rarely are when they violate the ethical rules. But they should also be held accountable at the ballot box. 90% of all criminal cases are handled in state and local courts. Only about 10% are in federal court. And of those 90% of the state and local, prosecutors are elected officials in all but 5 jurisdictions. There are about 2,400 elected district attorneys, state's attorneys that call different things in different jurisdictions. They run for office every 4 years. People rarely pay attention to DA races. You need to pay attention to DA races, folks. Vote them out of office if they are perpetuating racial disparities and perpetuating mass incarceration. And don't wait until election day. Contact your DA. Ask her, what is she doing to end this scourge of mass incarceration? Let your voices be known. And I'm happy to say that there is a movement, it's a small movement, but a growing movement of progressive prosecutors, that is people who have run for office, run for district attorney on the platform of ending mass incarceration and ending racial disparities. And they are winning. Many of them are winning. Larry Krasner in Philadelphia, Kim Fox in Cook County, Kim Gardner in St. Louis, Chesa Boudin in San Francisco, George Gascon in Los Angeles. I could go on and on. These are people who ran saying, I'm going to do everything in my power and discretion to end mass incarceration. I'm going to oppose cash bail. I'm going to set up a meaningful wrongful conviction unit, not just one for show, but a meaningful one. I'm going to set up a sentencing review unit where I go back and look at whether some people are serving too much time and I fight to get them out. I'm not going to charge juveniles as adults. I'm not going to seek the death penalty, right? And I'm going to take affirmative action to try to reduce the racial disparities. There's a program at Vera run by a woman named Jamila Hodge, called Reshaping Prosecution. And she has an initiative called Motion for Justice. I urge you to Google, not now, not during our talk, but later. I urge you to Google Motion for Justice and put in Vera and go and look at the outstanding work that they are doing to help prosecutors who truly care about this issue and truly want to use their power and discretion to end mass incarceration and to end racial disparities in the criminal justice system. So I'll stop there. Thank you.
Professor Davis, I hope that you can see me applauding here. Thank you for that galvanizing and inspiring and really crucial call to action. We're so grateful to you for being here today. I also want to thank you for the unwitting plug for the rest of our symposium, because on March 25th, we'll be joined both by Jami Hodge and Chesa Boudin. So yay.
I'll be there.
Yay,
I'll be there.
even better, yay. So before we move on to Mr. Ramsey, I just want to introduce our amazing and endlessly supportive Dean, David Lopez. Dean Lopez joined the Rutgers faculty in August of 2018 after serving as general counsel to the EEOC in the Obama administration. He is a nationally known and revered civil rights lawyer, and we're thrilled to have him both with us generally and with us today.
Thank you so much, Professor Cohen. Thank you so much, Professor Davis. That was outstanding. And what I really loved about that talk is that you came up with some action items. And that is so critical in this area. So thank you for joining us. I guess I'm sort of like the commercial in the middle of the program. So I'm gonna be a very short commercial. But I do want to, definitely give a shout out to the Center on Criminal Justice, Youth Rights, and Race for the latest in a series of truly outstanding national programs, which are really putting the focus on disparities in the criminal justice system. The work of the center, Professor Cohen and her fellows, has been absolutely tremendous. And this is really the latest chapter in that. Also a shout out to the Rutgers Law Review for co-hosting this symposium. Of course, it's always great to see Editor-in-Chief Gail, I call her Madam Editor, who is centrally involved with this, and Gisele as well. Both of them are working on not only their JD degrees, but they already have their GSD degrees. Get stuff done, and doers are what we really need. For those of you who have heard me speak, you will often hear me say, we shouldn't call this a law school, we should call this a justice school. And that we really hope that when people graduate from Rutgers, that they take the whole concept of justice, as amorphous and as it may be, as serious, and that they engage in serious conversations about what justice means. And that is really the centerpiece of what this program is about, that we are talking about justice in its most profound, most human sense. So again, I really appreciate everyone for taking their time out on a Friday afternoon to join this, and thank you all.
Thank you, Dean Lopez. Thank you so much. Our next guest, his name is John Ramsey, and he is currently the president and founder of Liberty Investigations. John Ramsey and I usually refer to him as Ramsey, had a lot of conversations in the lead up to this event. And he, he was wrongfully convicted, spent 33 years in prison for a crime that he didn't commit. And after being paroled, he just didn't go hide. He decided to found Liberty Investigations, where he closely works with inmates and former offenders to review and investigate cases of wrongful conviction. It is my pleasure to introduce my friend, John Ramsey.
Thank you. I appreciate that. As you know, my name is John Ramsey. I spent 33 years in jail. I went to jail when I was 21, came home when I was 55 years old. What stemmed from my incarceration dates back to 1981. There was a crime that transpired in East Flatbush in Brooklyn, where a person was murdered. The murder took place based on drug relations, right? I had absolutely nothing to do with the crime whatsoever. The crime happened in 1981. I was arrested in 1982. At the time that this crime happened, 2 people was arrested for this crime. And when the crime took place, the officers picked up 2 guys, and the relation to the crime comes from 2 people or 3 or 4 people or 5 people in the apartment who said that the person that committed, or the persons with a plural that committed the murder, is in Boney's Bar. And they gave them a description. Now, keep in mind, right, I had no knowledge of this whatsoever. I was arrested a year later. So the arrest takes place. These two guys is brought into the precinct and they are arrested for the crime. So now they was eventually let go. Now, during the void of the arrest, one of the guys mentions my name. The guy that mentioned my name, we date back from when I was 18 years old. I'm 21 when this crime took place. He was trying to actually have a relationship with a girl that I had a relationship, and it never could happen. So he had a problem with that. So he always had a beef with me. So now here we are, we go into 1982, I'm arrested for this murder. When I'm arrested, I have absolutely no knowledge of what's going on. So now the officer said, no, you was a part of this particular murder. I said, I had nothing to do with anything. So now when this transpires, the officer arrests me, I goes through the grand jury, and most people, the lawyers would tell them, don't go to the grand jury to testify. But I opposed that. I went to the grand jury to testify because I knew I had nothing to do with anything. So now, fast forward, I get my legal papers. When I get my legal papers, I realize that it's two people arrested for this crime. I know I was never arrested for this crime in 81, period, because I had nothing to do with anything. So now, as time go on, I'm arrested and eventually I get convicted of this crime. I had this is a one ID case. Now the one ID case stemmed from a guy named Thomas Dale. Thomas Dale comes into court and IDs me. But when I look at the DD5s, he originally said I wasn't the guy. He said I looked like the guy. He left the precinct for 5 or 6 hours and came back and said I was the guy. Now I'm a fast forward. We go 36 years later through the own DA's investigation at the CRU at Brooklyn DA's office. They go and investigate the case. When they go investigate the case, one of the female witnesses tells them that what happened was we went to the victim's brother's house and we went and told him that Green died, he was shot. The brother tells them, Dale, I know you had something to do with my brother's murder, which is the only witness in my case, identification witness. He tells him, I know you had something to do with my brother's murder. He in turn comes back to the precinct and identifies me through a photo, right? Now, during the Wade hearing, Michael Vecchione, who was my lawyer at the time, Michael Vecchione became the chief cadre, no, the chief of rackets at Brooklyn Supreme Court. He became pretty much the second in command under Hines in Brooklyn Supreme Court. He was my lawyer. Now, fast forward again, we go to 2006. I put in for a FOIA. When I put in for a FOIA, they accidentally gave me the police report. A police report where someone else was arrested the same night that this crime took place. That wasn't me. So come to find out, when I look at the police report, it talks in plurals that a second person was arrested for this. But I always knew that based on reading the DD5s, that someone else was involved with this crime, but I never knew who that person was. So now when I get this police report, my idea is to get out. Whatever I got to do to get out, I'm going to do to get out to these streets so I can find out exactly who this second person was. Come to find out, I eventually get parole. When I get parole through our investigation, we find out through him, through the co-defendant that they gave me, and through the DA's investigation at the CRU, that the person that was the second person that was arrested was actually the guy's brother. When he originally got arrested, he gave the police and the DA my name. He said, the person that you're looking for, his name is John Ramsey. So in terms, he actually directed their investigation. Now, the funny thing is the fact that the police never, ever came to my house. And I only live 2 or 3 blocks from this precinct. They never came to my house after he gave them this information. And furthermore, he gave them additional information and told him, oh, the person that was down with him that gave these guys the gun, his name is Lee Ellis, and he lives at 29th Street. The police goes to that particular location and no such person actually lived there at all. Now, you had 5 or 6 witnesses. Not one of these witnesses mentioned a scar on my head. I got a visible scar on my head. None of them mentioned. You had one witness that said that she was on the phone and the guy that came out of the bar, because this was connected to a bar, from the bar to the actual apartment where the murder took place. She said the guy, the shooter, came out and she was talking on the phone, and I asked her how long would she be on the phone, and she said, "Oh, I'll be a couple of minutes." And she told the prosecutor, she looked at me for a whole minute. A minute is a very long time to look at a person. And now we go fast forward to the trial. We get to the trial. Do you know the DA never asked her, the person that you've seen standing by that phone that was the actual shooter, do you see him in the courtroom? They never, ever asked that. Now, fast forward further than that, when we get to 36 years later, when the DA, this is their own investigation. It's not my investigation. It's their investigation. When they talking to her, they re-interview her. She never, ever mentions anything about a phone. None of that. She doesn't say anything whatsoever. Then we have another witness where they go to speak to her. They called on the phone. And she said the police told her the person that committed this murder is in the precinct. And this is the same night it happened. I was never, ever in the precinct. Then we have a jacket, mysteriously now, and we have the number to the jacket. What they call that, like the store in the jacket, right? And they never, ever want to produce this jacket. We tried to get them to produce the jacket to do in DNA, because I know positively my DNA is not on there. I know that for a fact, right? Then we wind up tracking down Officer Sullivan. That's the one that interviewed the co-defendant's brother when he was also picked up that night. And when they interviewed him, he says there has to be a DD5. We have no DD5s, right? We went to court. When we go to court, on the police report, Michael Vecchione came into the courtroom, came into the law office and gave us an affidavit, because he was my attorney at the time. And he said, no, we never had this. And we get all the way to the court. When we get to the court, Judge Leo asked the prosecutor, did you turn over this police report? And the DA says non-disclosure. He never, ever turned it over, period. Never turned over anything. And they still denied my motion for a hearing, which no one can understand. How would you do that? How could you not tell me this is not Brady? How could you not tell me when you got an officer that said he interviewed the persons that was locked up that night that fit the description? And then later on after that, the DA, this is 36 years later, the DA went to interview the officer Plunkett. He was the arresting officer that picked up these 2 guys based on the description. They went to him 36 years later. So now, if you went to him to ask him what was the description given, why would you wait 36 years to go do that? When if you turned this over 36 years prior, we would have knew that. We would have knew that, because he said, I don't remember. But now when you look at the overall case, we had a Wade hearing, which is identification hearing. At the Wade hearing, you got Officer Plunkett, which is the arresting officer. He never ever mentioned the fact that you had Cole Coleman and you had Dwayne Coleman, which is the brother. He never ever mentioned the fact that when the arrest took place, it wasn't just him, it was his brother. They eradicated that out. Even when we got to trial.
Ramsey, I just want to let you know you have 5 minutes.
All right, even at trial, they did the same thing, right? They didn't bring that up, right? Eventually, I make it home, right? When I make it home, I meet Craig Phemister, which is a lawyer, and I wind up going to Napoli and Skolnick. That's who handles my case. And I wound up meeting after that. I started this investigation firm. Through the investigation firm, I meet Earl Ward and Richard Emery, and I start doing what I do. And based on the fact that, based on my own situation, right, I have a passion for what I do. And how good are my investigative skills? Just look at the people that hire me. Earl Ward is one of the top lawyers. Richard Emery is one of the top lawyers. Craig Phemister is at the top. You know, this is my ideal guy. This is who got me to where I am right now. But when you look at wrongful conviction cases, and I work on a lot of wrongful conviction cases, there's so many different scenarios to it. Then you try to determine whether it's, you know, whether it's economics or whether it's race, right? Because I can show you cases where economics made the difference, right? When you look at OJ case, it made a difference. He was able to hire Alan Dershowitz and countless others, right? When you look at Irv Gotti with the government, with what was that? Dealing with money transactions, dealing with Supreme Team out of Queens, he had money, right? So now you try to determine what leads, whether it's race or whether it's economics, right? Because if you break one down, if you break the economics down, you still have the race. You break the race down, you still have the economics. So which one actually leads? Because if you break one down, you got to break the other, right? This is my belief. So now the way I do things, and most people, you know, they don't understand why I do that. I don't try to hurt people financially, right? Because of what I've been through. You know, unless you set up in a cell for 33 years, you will not really understand my position with it. Some things I do pro bono, you know, because of what I've been through. But my case, and I was just trying to, you know, speed it up because of the time slot situation, but it's a lot more to it. When I tell you a lot more to it, you know, I had identification expert, renowned identification experts that looked at my case. And it's hard to get into it in 15 to 20 minutes. But if you want me to send you my case where you can really sit down and read it, is more profound than I actually is able to explain in 15 minutes.
Mr. Ramsey, thank you so much. First of all, for what was a really incredible and successful effort to summarize such a long and complicated situation in not very much time, but also, more importantly, for sharing your story and all of the pain and harm that's embodied in it with us. So you touched on several points at which prosecutors made decisions that had a probably outcome determinative impact on your case. So the decision not to turn over Brady or exculpatory material to your legal team at the time of trial, the efforts to hold back access to physical evidence at the time of your trial, the failure to follow up on leads and to make sure that that every eyewitness was not just fully interviewed, but that there was some real assessment made of the validity of their statements, and most importantly, the what seemed to be efforts to evade or avoid introduction of evidence that would be contrary to the prosecution's determination to seek a conviction. And these are the kinds of factors that we see at work over and over again in wrongful conviction cases, and that go to the heart of why we have the rate of wrongful conviction that we do in this country. So we're very grateful to you for sharing your story with us. There is probably no one in this country better equipped to and more well-versed in the ethical considerations that underlie all of those prosecutorial decisions than Ellen Yarashevsky. I have to start this out by saying that it has been a goal of mine to get Ellen back to the law school to give a talk like this, probably for the entire time that I've been at the law school. She is an illustrious alumna of Rutgers Law School, and it is just a thrill to welcome her back. She is also the Associate Dean for Research and Faculty Development, the Howard Lichtenstein Distinguished Professor of Legal Ethics, and the Executive Director of the Monroe H. Friedman Institute for the Study of Legal Ethics at the Morris A. Dean School of Law at Hofstra University. Before she was at Hofstra, she was a clinical professor of law and the executive director of the Jacob Burns Ethics Center in the Practice of Law at Cardozo Law School. She is a legendary defense attorney. She has done innocence work herself. She has taught at Columbia and Fordham, and she is a prodigious scholar in a number of areas, but for our purposes today, on the question of prosecutorial ethics. Professor Yarashevsky, it is such a pleasure to have you here with us.
Well, thank you so much, Professor Cohn. I'm not sure I could live up to that long introduction, but probably what I'm most proud of is I'm a member of the People's Electric Law School from the class of 1975. So I want to thank the Law Review, particularly. I want to thank Giselle. I want to thank Madeline. Professor Cohn, you've been remarkable in putting this together, so thank you, and thank your center. And of course, Professor Davis, for that inspiring talk. Thank you so much. And Mr. Ramsey, you don't know this, but I've heard you speak a number of times. I'm quite familiar with your case. Your lawyers are among Earl Ward, the people you work with are people I know really well, and I can't thank you enough again for being so inspiring and being willing to share your story. And I really do encourage people who are on the Zoom to learn more about it. I'd be remiss if I also didn't tell the students that you should know that Professor Cohn herself worked for, I don't know how many years, 11 years on Mr. Burton's case, and worked tirelessly on a very well-known case in the Bronx of a man who was recently exonerated as well. So I encourage you to look at that. I'm going to talk about two things, but mostly I'm going to focus on why in cases like Mr. Ramsey's, so why does this happen and what do we do about it? As Professor Davis said, prosecutorial accountability. And then at the end, I just want to spend a few minutes focusing on why we should change from the model of prosecutors as gatekeepers. So let me start with this. I wish that Mr. Ramsey's case were unique. Unfortunately, it is not. Since 1992, when the Innocence Project began, there's been significant and increasing attention to prosecutorial accountability for misconduct in the courts, somewhat, and disciplinary authorities, hardly, but somewhat. Prosecutors' offices and defense organizations are starting to pay more attention to this. In 1992, the idea that someone was innocent just was unheard of. I mean, people did not believe that at all. At least now we know that there's attention and significant attention to wrongful convictions. There are the National Registry of Exonerations, and I'll put their report in the chat. They issued a report in 2020. There are 2,400 exonerations in the country. 30% of those involve prosecutorial misconduct, 35% involve police misconduct. Overall, government misconduct by the police and by the prosecutors. Typically, the greatest error by prosecutors is failing to turn over evidence, whether it's exculpatory, as in Mr. Ramsey's case, or impeachment, meaning that you can use the evidence to show that the witnesses are not telling the truth or to challenge their credibility. that exists in 54% of cases, right? We call this the suppression of evidence, and there's been reference to the term Brady. Brady's a Supreme Court case in 1963. And as a result of that, prosecutors are required to turn over exculpatory and impeachment evidence. And as I've said, it's one of the major cause of wrongful convictions involving prosecutors. There are 4 other causes. There's eyewitness identification, false confessions, forensic evidence, but government misconduct is one of the major ones. There's disagreement around the country as to whether these are an epidemic. There's a judge who famously said this is an epidemic, Brady violations, or whether they're what prosecutors called episodic, meaning they happen here and there, but it's really only a few bad apples and it's not a systemic problem. You know, I believe it's a systemic problem, as do many people who have studied this throughout time. But the problem is we won't know, we can't prove that because Brady is really hidden. The prosecutor's sitting there with the evidence. As Professor Davis points out, in 95 to 97% of cases, people plead guilty. And so you don't know what they're hiding and you don't know what's not being turned over, right? What about the cases, though, which we can show what we call misconduct? And let me just stop for a second and identify misconduct. You know, in law, misconduct is different than what you think it might be, right? When you think of misconduct, you think the individual intentionally did something. And that's true for a number of prosecutors. It's certainly true for a number of police. But in law, to reverse a case because of prosecutorial misconduct, it can be that the police failed to turn over information to the prosecutor, and even a good prosecutor who tried to get that information from the police was unable to do so. It's not that prosecutor's individual fault, but it's the fault of the system. It's the fault of the government, and that's called prosecutorial misconduct. So many prosecutors bristle at that term. They hate being accused of misconduct. Of course, nobody wants to be accused of it, when particularly it's not their fault. I like to think of it as government misconduct. So for purposes of this, I'm going to just talk now about a number of cases where we talk about actual knowing or intentional misconduct by prosecutors. I don't know, Mr. Ramsey, in your case, whether there was proof that in your case, the prosecutors were just negligent, the way they are in a lot of cases, and they were just sloppy and didn't turn it over, or whether they did it intentionally. But there are there's no consequence virtually, even for prosecutors who have done this intentionally. And we can talk later about why that might be true. You know, throughout our systems, we keep talking about in democracy, we have to have transparency, we have to have accountability. Professor Davis talked about accountability, but when it comes to prosecutors engaging in misconduct, we have neither. We have neither. As Professor Davis points out, there's very little transparency about what goes on in their offices. Certainly, there's very little transparency about the material that they're sitting upon that they get from the police or elsewhere, and whether they turn it over to the defense. And in terms of accountability, you might say, well, what happens to the prosecutor who intentionally fails to turn over evidence that shows that the person who's charged with the crime didn't do it? Well, I will first say that most of the wrongful convictions, by the way, if you ever go up on a stage at an Innocence Project event, about 90% of the people who are released are African-American or Latino, right? It is remarkable that what we're talking about when we look at our system of wrongful convictions, most of the people wrongfully convicted that we now know of, whose cases were exonerated, are people of color. And we can ask questions about what goes on here, such that those are the people who are wrongfully charged by police. So the one case the most famous case where a prosecutor was ever disbarred is where there was a combination, as Mr. Ramsey's pointed out. You know, if you want to put it the opposite of race and class, the Duke lacrosse kids. If you may remember, the Duke lacrosse players, a group of white, well-heeled lacrosse players, right, were charged with a rape. And in 2007, that district attorney himself, Mr. Nifong, he was disbarred when it became public and front page of newspapers that he not only did he fail to disclose that their DNA didn't match, but he engaged in a lot of other misconduct. He was disbarred. He was disbarred, and that was a case, where the defendants here are white and they have money. Another case, Ken Anderson was a prosecutor in Texas. There was a white man named Michael Morton, walked in one day and found his wife and child bludgeoned to death. They immediately blamed him. He spent 25 years in prison for the murder of his wife and child. He didn't do it. That prosecutor, who later became a judge, had hidden evidence, a significant amount of evidence that Michael Morton was not the perpetrator. So a few years ago, because of a unique procedure in Texas something called the Court of Criminal Inquiry, it's like a criminal trial for a prosecutor. They put Ken Anderson on trial. He's the only prosecutor around the country to ever serve a jail sentence. He spent 10 days in jail for his actions in the Michael Morton case. Once again, relatively well-heeled white defendant. We're really pleased he's out of prison. He's a terrific man. He's done a lot of work as well on wrongful convictions. And the only good news, I suppose, about that is that his case led to significant change in discovery laws in Texas, and they had the best laws in the country up until a few months ago, when New York also changed its laws, so that information has to be disclosed to the defense. Okay. California, an entire office in California was disqualified, the whole office, because there was a scandal where they systematically hid evidence and they colluded with jailhouse informants and had a secret database for decades. Most of the people involved there were people of color. No discipline for any prosecutor involved in that case. No discipline whatsoever. The good news there, the silver lining, California made it a felony. It is now a crime if you intentionally hide evidence if you're a prosecutor, something that we suggest should be adopted elsewhere. And perhaps the most notorious case is that of John Thompson. John Thompson was on death row in Louisiana for 5 separate times. Case kept getting reversed on appeal. And just a month before his execution, a young woman, intrepid investigator, located the fact that there had been a blood sample that had never been turned over. And it turned out that the prosecutor in that case, a man named Mr. Deegan, he had taken the blood evidence home with him and he kept it in his garage for years. He was worried that Thompson wasn't guilty, right? He revealed the existence of the blood sample in his garage to another district attorney who ultimately came forward after Deegan died of cancer. John Thompson's case ended up in the Supreme Court. It's another story, but he was ultimately exonerated. And he went on a national tour with the Innocence Project. And I was often with him when he'd say something that was so chilling. He would say, the prosecutor tried to kill me. Why wasn't he indicted for homicide? A great question to which a lawyer's answer is really insufficient, which is it doesn't meet the definition of homicide and you know, blah, blah, blah. You can go on there. But chilling, extremely chilling. Federal court, we have a number of cases that have been in the news of late where slowly courts are beginning to pay attention. One of the best judges on this issue is a judge in DC named Emmett Sullivan, who has repeatedly tried to hold prosecutors' feet to the fire by issuing rulings. In one case, the Ted Stevens case, Ted Stevens was a senator from Alaska, and Judge Sullivan watched how the government slowly just never turned over the evidence. So he finally said, in my 25 years on the bench, I've never seen mishandling or misconduct like what I've seen in this case, right? And so slowly we're seeing more judges pay attention to this, but very few and far between, right? And we can ask the question, like, why is it? Why is it that prosecutors are not disciplined in very few disciplinary cases? There was recently one in New York where a prosecutor was suspended for 2 years, and I don't have the time to go through the details, but I would suggest to you that that prosecutor should have been disbarred. The disciplinary committee that holds their hearings in secret in New York, right, has a hearing in secret. And then they issued a ruling saying, well, there was such mitigating evidence that this man's name was Kurtzrock, that Mr. Kurtzrock had never done anything like this before. Well, it turned out that the front page of the newspaper had for months been talking about other cases in which he was implicated for doing exactly the same thing. In one other case, hid 45 pieces of exculpatory evidence. And so despite the fact that the Innocence Project came forward and asked the disciplinary authority to reconsider, they have not done so. I will just say that I am somewhat optimistic that as we pay more attention to wrongful convictions, right, that there will be some more accountability for prosecutors, but it's going to be slow and well, let me just say very slow. I'm not so sure we're going to make progress anytime quickly. I'm happy to talk about that more, but before I relinquish my time, I still have some time, I want to talk about, I want to go back to what Professor Davis talked about, starting with the progressive prosecutors. You know, we're looking now at ways in which we can change this paradigm. And there are various ways in which the prosecutors are doing so. So to some extent, they're using their discretion not to charge certain crimes, right? Not to charge marijuana, not possession of marijuana, not to charge turnstile jumping. In some cases, not to charge low level of theft. Or just not enforcing certain crimes at all, right? Coming up with more diversion programs, police accountability, requiring greater accountability from police including having databases of of police who have engaged in misconduct in the past and turning that information over. These are important, very important mechanisms that police ought to be held accountable for, and important mechanisms for prosecutors to use to actually change the paradigm. But I want to push it even further, because I do not believe that we should look at this as prosecutors being the gatekeepers to all of society's ills. I mean, right now, prosecutors are the gatekeepers. Matters of social problems, whether it be jumping turnstiles, petty theft, mental health issues, kid brings a knife to school to protect himself, assault, homicide, it all runs through the prosecutor. And we have just learned to accept, well, that's the way it is because these are violations against our society. And I think it's time that we really have to step back and we have to say, what is the appropriate role for a prosecutor and why are we asking them to be the gatekeepers? I do not believe that they should be the gatekeepers for most crime. We can talk about crimes of violence and how those should be handled. But when you go out and talk to communities, the communities themselves do not want that 17-year-old, maybe who brings a knife to school to protect himself, to be put through the system. We know the harmful effects. We know the racial disproportion of the kids who are put through the system. We know about the school to prison pipeline. And I want to suggest, and these are some practical suggestions that we can make, that as we move from hopefully a punishment model to a rehabilitative and restorative model with racial justice at its core, that what we really have to do is start thinking of concrete ways to return the power back to communities. I mean, partly the defund the police movement or reorient finances of the police to the community attempts to do that as well. And I think we need to do it in terms of prosecutors, which is to say, prosecutors they get lots of money. They get money from the state. They get money now from the Department of Justice, from the Office of Justice Programs, and many of them engage in partnerships with community groups. But I want to suggest that it shouldn't just be partnerships with community groups, that the money should go toward programs that actually build up those community groups such that when there is an issue, when there is a kid who takes a knife to school and we want some help for that kid, they shouldn't be brought to the police and they shouldn't be put through the system through prosecutors. Instead, there should be some community-based mechanism to help that kid with whatever that kid needs. When we talk about the defense, we look at a holistic model, which is to say, we want that defense organization to help the person with all of their needs. And I want to look at prosecution as somewhat of a holistic model, which is to say, don't put people through the system, find alternatives for them to get help. So that one idea, for instance, is you make a school system, a school 24/7 place where they have all kinds of community resources for people. They have mental health resources. They have social work resources. They have ways to help people with housing. They have ways to help people with food stamps and transportation, whatever else they need, right? Such that when there is an issue, instead of police taking cases to prosecutors, you have social workers taking people to community groups such that we don't bring cases to prosecutors. It may sound odd to say prosecutors have a responsibility to make that happen. This is Professor Davis's, I'm following up on her notion of responsibility, but I think they do. I think they have a responsibility when they're applying for grants to think of those grants when they want to talk about stopping gun violence as fundamentally problems that need to be solved by the community, and they need to think of ways in which long-term they can help support those community resources. Because if we don't do that, if we don't revamp and rethink our criminal legal system and constantly are just minimizing the number of cases that go through the system, right? That we're just not going to charge certain crimes. They're usually low-level crimes, right? And if we're just, that's all we're thinking about, we're not going to fundamentally alter the way in which Black and brown people, and particularly Black and brown people without financial resources are treated. You know, as Mr. Ramsey points out, the intersection of race and class is right up front when it comes to the people put through the system. And I think it's incumbent upon prosecutors to give up some of their power, and they have to give up their power to the community.
Thank you so much, Professor Yaroslavsky. That was also invigorating and insightful and galvanizing. So we wanted to start the Q&A. First of all, I need to tell all of those who are out there who want CLE credit for this that the first code is JUSTICE, JUSTICE. I think it's all caps. We wanted to start our Q&A here first by reminding those in the audience that if you have questions for the panelists, please put them in the Q&A. We're going to try to get to all of them. But I want to throw this out first. Both Professor Davis and Professor Yaroslavsky touched on the difficulty of holding prosecutors accountable through criminal prosecution. I'd like to explore, first of all, where you think those difficulties stem from, other than the obvious that we have prosecutors prosecuting prosecutors and the nebulous nature of interpreting and applying the legal standards for criminal accountability. But also, are there other ways of holding prosecutors accountable? We've heard that ethical complaints don't really go anywhere. Criminal prosecutions don't really get anywhere. What can we do to hold the system as a whole accountable, but also individual prosecutors?
Go ahead.
Ellen, you can go first.
Oh, that's fine. I was going to say you could go first. Look, it's a multifaceted approach. First of all, I think the fact in the last 20 years since the internet, we're paying so much attention to this is really helpful, right? We wouldn't have had this discussion even 10 or 15 years ago. The fact that there's so many wrongful convictions, people now believe you can plead guilty, even if you're not guilty. We now accept that in the culture. So that's good. And I think we're slowly moving forward. So one, like in New York, we now are going to pass a bill to have a commission on prosecutorial conduct, where an independent commission is going to be able to hold hearings for prosecutors who are reported. So that's one. I think people can push independent entities to exist, number one. Yes, like California, you can pass bills to make it illegal to intentionally hide evidence, which is most of the reason for wrongful convictions. So you can do that. You can ask judges more frequently, that's happening, to hold sanctions. You know, but ultimately, here's the problem, and I think this is probably what Professor Davis will talk about as well. These are internal issues. Prosecutors' offices themselves have to take this responsibility seriously. And what makes that hard is in most offices, winning really matters, right? That's what they're focused on, how to win a case, which is why evidence tends to get suppressed in the less progressive offices. And so there has to be a culture change within those offices. And they themselves have to decide, we're not going to tolerate this anymore. We're not going to have prosecutors in our office who do these kinds of things. So that's training, supervision, various ways in which internally that has to happen. But it all has to happen as once. Is a prosecutor that Professor Davis mentioned, Kim Fox would say, changing a prosecutor's office is like turning around a battleship, right? It's really slow and it takes a very long time, but I'm somewhat optimistic that we can get there slowly.
Yeah, and I will just go back to what I said in my initial talk about electing people, and then not just electing progressive people who promise to, implement these new policies, but holding them accountable, holding the progressives accountable once they get into office. And it's difficult. Many of those, almost all of the progressive prosecutors who have been elected are getting a lot of pushback from within their own offices and outside of their offices, right? So, when they came in, when Kim Fox came in, Larry Krasner and others came in and said, we're going to decline the prosecution of this list of cases, and we're going to hold cops accountable. The police unions, the police departments, even judges, a judge was investigating Kim Fox for exercising discretion, something that the Supreme Court has repeatedly said prosecutors have the right to do. I mean, it's been crazy, the amount of pushback they've gotten. They've also gotten pushback from within their offices. George Gascon, who just got elected in Los Angeles, the assistant DAs in his offices are suing him because they don't want to implement his policies. So they're getting it from both sides, and it's a difficult job. But I think that the people who put them in office to make change should hold their feet to the fire, and it's up to the prosecutors to communicate with them, to be in touch with them. I mean, they've been getting it from the left and the right, like the people who voted them in to end mass incarceration are like, look, it's been 2 months. Why haven't you ended mass incarceration? And I think a lot of people don't understand, like, it's a process. It took us decades to get here. It's going to take time, but it's incumbent upon the prosecutor to include the community in their decision making, right? There are some prosecutors, I think Eric Gonzalez, there's who have these community boards that advise them on their policies and practices. So I think a combination of all those things. But we can't just wait until the time of the election, right? I mean, throughout, we have to stay on these prosecutors and make sure that they're doing, keeping their promises.
One other thing that we haven't mentioned, I think, is judicial orders. One of the moves now around the country is to have judges actually issue orders that prosecutors have to comply with X, Y, and Z, usually in terms of the information they have to turn over. But once there's an order, it's more likely that the prosecutor is going to pay attention, number one, partly because they know if they violate an order, they can be held in contempt. And that wasn't true before. So, it's a carrot and stick piece here.
Yeah. Although I wonder how willing judges are to issue those orders, especially in states that have open discovery rules.
Well, New York is going to be a very interesting experiment because we have this wonderfully progressive new discovery rule. And I will tell you, within a month of the new discovery rule, prosecutors were training people in their offices how to get around it, how to avoid it, right? And judges they don't want to do it either. There's a lot of them are law and order judges, and they're used to doing things a certain way. Our system in New York has always been a cat and mouse game. It's remarkable that in a homicide case, you don't get the name of a witness until you're in the middle of a trial. It's ridiculous, but that's the way it worked for a long time. And they're all so used to it that it's going to be really hard to change, but we've just got to keep pushing.
Yeah, absolutely. So one of the questions that came up in the chat, and this is, I think, to Professor Davis's last point, is that in New Jersey and in not a whole lot of other states, but in some states, we have appointed prosecutors, not elected prosecutors. And obviously that's true at the federal level. How do we apply that kind of political pressure that you described, or other kinds of pressure to, in your words, hold their feet to the fire?
Yeah, there are a few jurisdictions, I think 5, including the District of Columbia, that do not have elected prosecutors. But there's still a process, and you still have the right to be involved in that process. I think in New Jersey, I think the governor appoints the prosecutors on advice and consent of the state senate or something like that.
Yeah.
So it's still all about the messy business of democracy, because right, you elect the governor and you elect the state senators, and so you have to make your voices known. I don't know the specific process in New Jersey, how they line people up to, be appointed and all that, but learn what that process is, and then state your support for or objection to the people who are being considered for those positions. Because the governor, again, is an elected official. Your state senators are elected officials. And believe you me, they listen when voters contact them about things, because it doesn't happen that often. And so they pay attention because they want to get elected. Whoever is the decision maker, who you have the power to influence, is how you make your voices be known. And we need more good people to put themselves in line to be appointed and to run for these positions, right? And that's a hard thing to do. It's particularly elected prosecutors. It costs money to run, unfortunately, in the United States of America, and so it's not an easy process. We've got more and more people doing it, but we need more and more good people to step forward and be willing to take that on.
So in follow-up to that, actually, I'm glad that you brought that up about getting more prosecutors and training and things of that nature. If you had the opportunity to talk to a law student, to a 3L student who's trying to decide between who's committed to making change and wants to bring change, how would you tell them to go to a prosecutor office, or would you tell them to go to a defender office?
Ellen and I are smiling because we do this all the time. It's an easy question, it's an easy one, and it's a hard one, and I'll tell you why. What I say to my students is, I don't try to convince my students to either be prosecutors or defense attorneys. I try to convince my students to become one or the other. And then I do the best I can to train them to be the best in either way, right? So I teach a course that I followed behind my friend Ellen and got advice from her on, because she teaches it too, on criminal justice ethics. And it teaches ethics to students who want to be prosecutors and defense attorneys. So I'm trying my best to teach the students who want to be prosecutors what their ethical responsibilities are. I'm teaching them what Brady is. I'm telling them you got to turn over everything. I'm training them to be a progressive prosecutor. That's what I want them to be. And for the students who want to be public defenders, I'm training them to be strong, zealous defenders who do everything within the ethical bounds to represent their clients. So I think we need good, strong, ethical people on both sides who believe that we need to dismantle this criminal legal system that we have and make it more just. So I think you can do good on both sides. And I honestly think that there are students who in their gut lean more to one to the other. And I say, follow your gut. Like, Larry Krasner has gotten in a lot of trouble with the defense community because he goes to schools and he tries to change the minds of students who want to be public defenders to make them be prosecutors. So he tries to raid public defender offices to have them come to his office because he wants that defense mind in his prosecution office. I don't blame him for that. But, I don't think you can people are going to do what they want to do, what's in their gut. And I think we need good people on both sides. I will say this. There is a crisis in indigent defense right now that there is not on the prosecutor side. In other words, we need more defenders in terms of just sheer numbers. But again, I think you can do good on both sides. I hope that's not wheeling out of your question, because that's honestly what I believe. I think the problem, and I'll very quickly, the problem is all the students I know these days, thankfully, who come to me, thankfully are saying, I only want to be a prosecutor if I can be a progressive prosecutor. I don't want to work for a prosecutor who's, being carceral and locking people up. And I love that. The problem is, of course, there's only a handful of prosecutor offices like that, and students need jobs. And so they're in a real dilemma, because it's like, do I take a job working for a prosecutor who's not, really doing the kind of policies that I like because I need the job, or do I wait? That's a hard, for me to tell a student to turn down a job is a hard thing to do, but that I think is the dilemma and the problem that I think a lot of students face.
Angela and I, we talk about this a lot. We actually did videotapes over the summer that you might want to see, of Angela and me and several other people talking about these kinds of issues. We have another colleague who's, her view is she wouldn't be caught dead in the prosecutor's office. She just thinks they're, all their job is to put people of color in cages, right? That's fundamentally the role that you're playing in the culture. I don't agree. I mean, maybe that's what the end game is, but I think you have to have good prosecutors. We just did a program the other night about this, and my students in the course that Angela and I both teach, Ethics and Criminal Advocacy, were just so thrilled. They couldn't wait to go to a prosecutor's office that had been part of the program. But, because they think they're going to go and make a difference there. And the question is, who's the prosecutor? If you don't have someone like Larry Krasner or Kim Fox, who really wants to be there to make a difference, you're just going to be beating your head up against the wall. And, it's not like you can go in and say to the prosecutor, I'm not going to prosecute this case because the racial disparity in this case is so great, I don't think we should go forward. And then they say to you, you have to. Then what are you supposed to do, right? So the point, I think you can't be naive if you're going to go do that. You can't go into a prosecutor's office just thinking you're going to make a difference in the world. You might be able to make a difference in a few people's lives, maybe. And then, of course, there are people, there's pieces written like, can you be a good person and a good prosecutor? We did a whole symposium on that. It was inspired by the cocktail party question always asked of defense lawyers. How can you represent those people, right? So it's complicated, but I agree people should follow their heart. The problem, I would say, for students, and this is more true in New York, which tends to be more adversarial than most places, you really need to choose early on. Because if you think, well, I'll go work in a defender office one summer and the next summer I'll go work in a prosecutor's office, and then you go interview for a job, neither side wants to hire you because they think you're not committed. And that's really hard for students because I understand the instinct to want to try both, but you really shouldn't be naive about that either. You really need to go see a career counselor or Professor Cohn or someone at your school before you're going to make a decision that, well, let's try a little of this and a little of that.
Thank you. And Ramsey, you're not precluded from this question. So tell me, what do you think? Oh, you need to unmute yourself.
In particular, right, dealing with judges. When you talk about Brady, we're talking about evidence that was omitted from the actual proceeding, not just from the defense, right, but from the judge itself. When you look at the wrongful conviction cases, you never ever, I haven't seen one time where a judge come out and talk against the prosecutor for withholding information, exculpatory material, not only from the defense, but actually from the judge. So the judge sentenced this guy to 25 to life, right? Not knowing that what came before that was never existed because they never turned it over. And it's just like when you see cases, Eric Gonzalez and quite a few other prosecutors, right? When they overturn cases, they get out in front of the court building, they sitting out there and they smiling about actually, oh, I exonerated this guy. But where do the smile come from? Is you serious? Where you didn't destroy the whole family. It's just like my situation. I lost like 80% of my family in the process of that. Then you got judges that don't even stand up against it. You're supposed to be talking. You the one that actually had me stand in front of you and you giving me 25 to life for something that I actually had nothing to do, based on the fact that the evidence that was in my trial that would have proved that I was innocent was precluded from my trial, period. And not only, and even going further in my own personal situation, in my pre-sentence report, when I was going to the parole board, prior to going to parole board, you meet with a parole officer. Now they changed it where everything is run through a counselor. And I sat up there and I'm talking to him. He said, Randy, I said, I'm innocent. He said, how could you be innocent? You got 6 people identified you as the shooter. This came through the pre-sentence report. This is something that goes through the judge. The judge seen this pre-sentence report and knew it was inaccurate, but let it go anyway. And they showed it to me. And you go through my trial, only one person picked me out. That was it. And we know why he did it. So the judge actually, in my opinion, I don't care what no one say, was a part of that, because you knew that. You're the one that processed. You go to probation officer, then you go to the pre-sentence where the judge gets the pre-sentence report and signs off on this pre-sentence report. So why is not judges standing forward when they're being deceived? Because they actually are being deceived by the DA's office. And let me point on one thing. I just signed a contract with a production company, right? A very renowned production company. And through this production company, a lot of my investigations is going to be.
Ramsey, I'm so sorry, but
Yeah.
we only have 30 seconds.
All right, 30 seconds, I'm gone.
Yes.
And through
I'm
that
so sorry.
it's going to come out. The information that I have is going to come out.
Good, good.
And that's no one understands what I've been through and why I have such a passion for what I do. Right? But I know one thing: in order to put them on the plat, you got to expose them clearly. And that's my thing, is exposing them clearly. What I have on them is nowhere you can walk back off of. And they have great power. So I realize in order to beat them, I got to have equal power as they have.
Thank you so much, Ramsey. Thank you so much. Okay, so I'm going to go to a question from the chat. When a conviction or sentence is overturned on the basis of discrimination on the part of the prosecutor/judge, is there an effort to create some imposed automatic penalty to them without the exonerated having the burden of pursuing the legal matter? Would that be possible or an effective deterrence?
I don't think a case is being overturned because the prosecutor or judge was discriminated based on race in their official duties, because I'm not aware of any cases like that where that has happened. I mean, Ellen, help me out here.
No, that doesn't exist. I don't know if the question really was about discrimination or misconduct.
Yeah, that's what I just read.
So I would just, there's nothing under, look, it would be nice to say the judge engaged in discrimination, right? Or the prosecutor, you could prove it, but that would be really hard to prove. You really can't. But if the question's about misconduct, it's a great question. And here, if in fact the case is reversed, it takes a lot for a case to be reversed. It's not just they engaged in misconduct. It's like, but for what they did, the result would have been different. And that almost never happens, which is why all of these cases, by the way, like Mr. Ramsey's, they all gone through the appeals process, and every appellate court says, oh, we're not going to overturn it. We're not going to overturn it because look, the evidence is so overwhelming. Like in his case, all these eyewitnesses, right? So it's really hard to get a case overturned. If you get a case overturned, it would be great if in every single one of those cases where there's a finding of misconduct, it automatically has to go to a commission to examine the conduct of the prosecutor, right? Or the judge. Mr. Ramsey is completely right. We haven't paid any attention really to judicial responsibility for what happened in these wrongful conviction cases. We've been focusing on prosecutors. It would be great to look at that as well. We haven't done that yet, right? So I don't know if that's an answer to the question, but if it's discrimination, that's not going to happen.
Yeah, I just looked at the question, and it does say discrimination, and I get the question because yes,
right,
you do engage in discrimination. Judges do too, but for all the reasons I mentioned in my initial talk, it's really difficult to prove, and because we're in a system where the jurisprudence, at least constitutionally, is that you have to prove intentional discrimination on the part of the actor. It's really hard to prove intentional discrimination based on the way it's been interpreted by courts. And so, you know, you'd have to have some smoking gun, and that's not usually the way it happens. It's usually a lot more complicated, discrete, implicit bias, and otherwise. So it's really, really hard. So that's why I suggest these other ways of dealing with, you know, the harm caused by prosecutors and judges, as Ellen pointed out, because unfortunately the case law is not helpful to us.
So in the chat, there have been a bunch of questions that sort of circle around the exercise of prosecutorial discretion. I'm wondering if we can revisit one of the points that you made, Professor Davis, and that is the not just implicit, but really buried bias that's hidden beneath decisional factors like, is this case likely to give rise to a conviction? And that plays out in all kinds of ways. So even when prosecutors are making decisions about whether to charge and what to charge, one of the factors they look at is the person's prior record. Well, of course, what we know is that in over-policed communities, people are much more likely to have records and have them at a younger age and have them with more charges and more convictions than people who live in white communities. So how do we, through training, through supervision, through promotional criteria, through some sort of process of truth and reconciliation, how do we get underneath that bias that's lurking at every stage of the exercise of prosecutorial discretion?
I mean, you know, the example you gave is such a great one because, you know, if you're going to have, and like I gave the example in the hypo I gave, you know, an African-American is more likely to have an arrest record for sure, and even a conviction record because of racial profile, right? And so what I think it requires is prosecutors, when they're making their charging decisions, to have the kind of training to not give such weight to prior record with that understanding. There actually have been a few cases, and it's slipping my mind, where judges, I remember Judge Nancy Gertner a long time ago, took into account racial profiling in making a decision not to sentence someone based on their prior record. So we need more training of prosecutors and judges, when the judges have the discretion to do so, to not put so much weight on the prior record. And that comes from having an understanding of how it is this person ends up with a record that it doesn't necessarily mean this is a bad person. It's because of all these, you know, this discrimination in the system. And I think I'm so glad you're having Jami Hodge come, because her motion for justice initiative is doing that kind of training in prosecutor offices. But they don't have to take that into account if they don't want to. That's the thing about prosecutors. There's so many things they just don't have to do, you know, unless they want to, and they have the power and discretion to do that. But it requires that training and education.
Professor Davis, is part of that having a community panel? Because people in the community groups who are talking about lived experience want to go to prosecutors and say, no, we don't want you to charge that kid with this particular crime. We'll take care of him instead. And so it would seem to me that that's one way around the problem of the bias, you know, explicit and implicit bias. Also, hiring more people of color. I mean, we're now looking at how we develop anti-racist law schools, right? Like, what do we do? And, you know, why don't we admit some people who have been in prison? You know, why don't we admit more people who come from a background of incarceration, who understand these problems and then can go on to be prosecutors? So, you know, it goes down to every single level of the profession.
I absolutely agree with everything you just said. And with one caveat, you know, you said hire more people of color. I want to just qualify that. Hire more people of color who believe in freeing Black and brown people from prison, because not all of them do.
I agree. Okay.
There are some Black and brown chief prosecutors who are just as bad as some. I mean, for example, George Gascon just unseated a Black woman named Jackie Lacey, and I'm so happy about it, because Jackie Lacey was locking up Black and brown people and seeking the death penalty. So, just want to put that qualification on there.
I agree.
So Professor Davis, in one of your articles in 1998, you advocated for using racial impact studies, to advance the use of prosecutorial discretion in a manner that's more, more responsible to the community and in a non-discriminatory manner. And the idea was to figure out, how race impacts the decisions that the prosecutors make. It's been 20 years later, and we're still having this discussion. Do you still see racial impact studies as being important to change? Where do you see this going nationally? And do you see this as something that even from state to state, we can see the use of these studies to be able to bring about the change that we're all looking for?
Yeah, well, the Vera Institute actually did some of those studies, right? They took my very sort of simple, undeveloped idea in my law review article and actually turned it into, something effective. Years ago, they had something called the Prosecution and Racial Justice Program, where they convinced several chief prosecutors across the country, including John Chisholm in Milwaukee County, who's still doing this great work, to allow their statisticians to come into their offices. It was a pilot program, and collect data on the race of the defendant and the race of the victim, and to look at various decision points to determine whether or not the decisions that prosecutors were making were inadvertently causing disparities. And they discovered that it was happening. And when they discovered it, the chief prosecutors made changes to try to reduce those disparities. I think John Chisholm did probably the best job of that, of the few prosecutors who tried it. Has that spread wider? That particular model hasn't, but I know Vera's still doing good work around this. A number of the progressive prosecutors are collecting data. They're being very transparent about what's going on. And I think that transparency and that data collection is helping to inform their decision-making in order to cause them to make decisions to reduce racial disparities. It is complicated, but I think there are a few prosecutors out there who are doing this work.
And I want to underscore what Professor Davis said before about the need for the public and communities to pay attention to this stuff, because the attention to prosecutors now is mostly about wrongful convictions, right? I mean, that's where the energy is. If we started paying attention to prosecutors the way we have to police, right, to policing around charging disparity, sentencing disparity, and that became an issue, we might see more and more movement. So that's like holding their feet to the fire toward the ballot box.
Yeah, and there have been a lot of comments and questions in the chat about exactly that issue. And so one of the things that keeps coming up again is we're calling the governor's office about property taxes. We're calling the governor's office about COVID vaccines, but we're not calling them about who's appointed to prosecutorial offices and how those offices are functioning. So I think that that's the takeaway from today, right? That we all have to pay attention and we all have to make our voices heard. So another thing that has come up in the chat is this question of all of the cases we don't hear about. So the 95% of cases that are charged in a particular way for really the sole purpose of provoking a guilty plea. And how do we go about getting under, and all of the misdemeanors that never make their way into the newspapers, never give rise to an exoneration. How do we get underneath really the primary function and primary focus of the criminal legal system? How do we hold that accountable? How do we shine a light on it? And what do we need to do to change those practices? Because without changing them, we really will not be able to accomplish any kind of meaningful structural change.
How many hours do we have?
I'll keep you here all night if you want.
I mean, education to me is really key, and getting journalists to write about this, right? having blogs, going on various social media sites to start talking about this. Do people know that like 87% of the cases in this country are misdemeanors? I mean, that's most of our system are misdemeanors, and they're mills, right? People show up, they get charged, they have to come to court, they go to court, they plead guilty, they leave. That's our system of justice in this country. It's not these fancy federal trials that we tend to see in the media. So we've got to reorient in part in the public sphere what the system is about. So I'll just start with that and let Professor Davis maybe pick up from there. We can go back and forth.
You know, I think people being educated about what's going on. And, you know, you mentioned, Professor Cohen, about how we write the governor about taxes and this and other, but we don't. And it's because until you or a member of your family is somehow involved in the system, people tend not to pay attention to the criminal legal system. And I get it. Like, who wants to be thinking about that kind of horrible stuff? But we have to, and we have to be vocal about it. People need to be organized. Like, education is good, but there are a lot of organizations out here that are doing work on this, from, you know, the Bail Fund to, you know, the NAACP Legal Defense Fund, the Lawyers Committee. The ACLU is doing a whole campaign now called Know Your DA. They're very involved in educating people about it. But having, you know, numbers and being organized and demanding better of your district attorney. Call your DA up, and, you know, don't do it as just one person. If you're with a group, it's even better. We want to meet with the district attorney, you know, your local branch of whatever organization. We want to meet with the district attorney to talk about the following issues: mass incarceration, racial disparities, bail, right? And educate, and that'll get their attention. They're not used to that. They're not used to people asking them anything. You know, it's sad to say, but most prosecutors, they run unopposed and they serve for decades. And if you are running unopposed, you have no incentive to do anything to be held accountable, because nobody's asking you anything and you just keep doing what you're doing and nobody's going to challenge you. That only changes with us making our voices known. And I believe it can make a difference. I really do.
I agree. You know, the one thing we haven't said, you know, is that the perception is that, you know, it's really the young guy with the hoodie, like the young Black guy with the hoodie, who is a person. So we're not going to care about him so much. Whereas if it were a white middle-class kid, this system would change. We would not have this system. You know, I once said, one of my classes, I brought someone who did juvenile justice, Professor Cohen, that you know, and one of my students said, well, what's the answer to a good system for juveniles? And she said, go to the suburbs. The suburbs have a great answer. They have a local police officer. Kid does something wrong. They bring the kid home. They talk to the kid. They're really nice. They figure out a system to try to help. And I think we've really got to start focusing. We want to talk about racial disparity. The fundamental racial problem here is we think this is a system for poor Black and brown people. And that's why there's so much lack of attention to it, unless if you come to wrongful convictions. And then a lot of people in the suburbs will go, oh, that's terrible. We shouldn't do that.
Yeah. Madeline, you want to chime in?
Oops, I was on mute for a second. I actually, as I was listening in, I was thinking about Brady. And I was wondering if, you know, part of the solution would be to somehow expand, you know, Brady and reform Brady in such a way that would allow or would force prosecutors to give more information and not less, and not pick and choose what they give. What do you think about that?
Well, that's what the new laws do, the law in Texas, the law in New York. And one of the things we haven't talked about is the ethics rule in every jurisdiction is broader than Brady. Brady is really just a case about what it takes to reverse a conviction, right? So yes, I mean, we should have broader laws, and people should make sure in your jurisdiction that you look at the ethics rule. It's rule 3.8D in the ABA model rules to ensure that that goes further. But Brady is just, it's really a wrongful conviction problem more than it is the fundamental problem that Professor Davis is talking about, which is how do we revamp the whole system?
Right, and that's the thing, you know, in my book, The Arbitrary Justice, most of what I talk about in that book is not what qualifies technically as prosecutorial misconduct.
Right.
It is the legal exercise of prosecutorial discretion, which is not illegal and most of it is not unethical, but it's causing these problems, right? So much of what they do is not considered unethical under the rules and is not considered unconstitutional, yet it is causing harm because of the exercise of their power. So it's going to require them to have the will to change that. And we are the ones who get them to do that, right? We determine that because we're the ones who put them in office. You're on mute.
Yeah, thank you. We have 2 minutes left, and I just ask if any of you have any final thoughts. I guess we should start with Mr. Ramsey. Mr. Ramsey, you're muted.
You're muted.
I just hope the system get better.
All right, hallelujah.
That's
Keep up your great work. Thank you for all your work.
Yeah, you are making the system better.
Yeah, for sure. Because I come with a passion. That's why. And generally, I don't give up on any case that I undertake. As far as investigating, I'm really into what I do. And even though you have different views, dealing with the criminal justice system, I don't hold no indifference about a person that think one way or the other. We all trying to reach the same goal. That's just the bottom line, in my opinion. You know what I mean? And your perception is your reality. But I think if collectively, if we come together, I think we'll be good. Sometimes, people have personal, I don't get into none of that personal stuff at all. I'm not really, the black, white or whatever. And I like how Davis and Miss Ellen, I like how they communicate. I like that collectiveness. And sometimes you could talk about race, but sometimes it's hard to talk about race to a white person. You know what I mean? And I try to live by example. It's like my son is 17 months old. The lawyer, Craig Phimister, that's my son's godfather, and he's white. You know what I mean? So I try to do things through example. But I love, the work you guys do, and I appreciate it deeply.
Thank you. We appreciate you too. So I just have 2 more things to say, and then I'm going to turn it over to Maddie to wrap up. The first is that the second and final CLE code is equity, EQUITY, not case sensitive. The second thing is that I'm sorry that we didn't get to all the questions in the chat. It was a very robust Q&A going on online, and I hope that we answered most of your questions. One thing that I did see come up was several suggestions that we have prosecutors on future panels, and we absolutely will have prosecutors on the future panels. The March 25th panel is made up, I think, almost exclusively of prosecutors and Jamil Hodge. So we look forward to seeing all of you then, and we'll get more information out about the upcoming programs. And then the final thing before I turn it back over to Maddie is that I want to thank all 3 of our panelists, Mr. Ramsey, Professor Davis, and Professor Yarashevsky, for being here, for sharing your thoughts and your insights with us. It has been a phenomenal way to kick off this series, and we're so grateful to all of you for being here.
Thank you. We're grateful to you for doing it.
Yeah.
Thank you for having me.
Yeah.
Thank you very much. And just as Laura, I would like to thank you all for attending. I'd like to thank the panelists, for being here and sharing your thoughts. Ramsey, thank you so much for bringing so much passion. I know that this is emotional for you, and I know that one of the reasons of having Ramsey here today is to demonstrate that this is not just about someone losing, a few years, many years of freedom, but that this has an emotional toll. This has an effect that is unbelievable. And it's not just something that you leave once you leave the prison, it stays with you. And Ramsey has decided to do something that a lot of us don't want to do, go back and try to help. And for that, I thank him. Please don't forget to look at our other portions of this symposium. March 10th is the next one. And then we're going to have March 25th, April 9th. Thank you all, and have a great night.